What if I told you that several Southern states were only restored to the Union after the American Civil War on one central condition: ratify the 14th Amendment? And what if repudiating the 14th Amendment should call that readmission into question? Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. That's the constitutional theory I want to explore today. After the American Civil War, the former Confederate states were not simply welcomed back automatically. Congress itself imposed conditions. The Reconstruction Act of 1867 placed the South under military administration and required the former Confederate states to ratify the 14th Amendment before regaining representation in Congress. No ratification, no readmission. This is historical fact. Adopting the 14th Amendment, ratifying the 14th Amendment, was the sine qua non for readmission to the United States, without which, not. So if acceptance of the 14th Amendment was the condition for restoration to the Union, then what happens when the political institutions in those states begin to repudiate the 14th Amendment openly? The thing is, the 14th Amendment is not some obscure procedural amendment. It is the constitutional foundation of modern America, in very real terms. The 14th Amendment to the U.S. Constitution is where we get the ideas of equal protection under the law, birthright citizenship, due process, and the application of the Bill of Rights to the U.S. states. Modern civil rights law largely rests on the 14th Amendment entirely. In many ways, Reconstruction refounded the United States around these ideas, and around the 14th Amendment in particular. So when a state starts openly rejecting the 14th Amendment, it's not merely disagreeing over policy. It's challenging the constitutional settlement that allowed it to come back into the Union after the Civil War. It would be easy to look at a situation like this and think that something this significant would require a constitutional amendment, but no. Admission into the Union has historically been governed by Congress, and Reconstruction demonstrates that readmission after rebellion was also governed by Congress. Congress imposed these conditions, Congress enforced them. Congress decided when the former Confederate states were worthy of regained representation. So while the Constitution does not explicitly provide a mechanism for expelling states, the idea that Congress has authority over the political recognition of states after rebellion is not invented out of thin air. This is well-settled precedent. Now, admittedly, this would require rehashing a constitutional debate and a constitutional conundrum that was exposed during the American Civil War. What process, if any, allows Congress to remove states from the Union? That is a far less well-settled issue, and in fact, the U.S. Supreme Court in Texas v. White described the Union as indestructible. But the historical premise remains real. Former Confederate states were restored to the Union conditionally. So what does that mean for modern politics? I think a lot of people misunderstand the current political movement, especially MAGA. Donald Trump is not the root cause of our current political division. He is a symptom of an ideological conflict that dates back to Reconstruction itself, and arguably all the way back to the founding of America. It's a conflict over federal civil rights enforcement, multiracial democracy, birthright citizenship, and whether the 14th Amendment should meaningfully constrain state governments. That conflict, unfortunately, never fully ended. And before anyone has a chance to say this is exaggerated, consider what happened recently in Alabama. During a dispute over congressional redistricting, Alabama House Speaker Nathaniel Ledbetter publicly stated that he hoped the U.S. Supreme Court would overturn Amendment 14. His office later tried to clarify the remark, but the significance is obvious. MAGA itself is increasingly hostile to the 14th Amendment itself. And just as an aside here, modern conservatives often like to remind people that the Democratic Party was once the party of slavery and the Ku Klux Klan, and historically that is accurate. But Republicans were also the party of Reconstruction. The Republican Party was the party that imposed the 14th Amendment on former Confederate states as a condition of readmission. So the next time a Republican says, oh, well, the Democrats were the ones who found the KKK, flip the script on them and ask them, well, the Republicans were the ones who were responsible for birthright citizenship, so why can't you support that? Now, I understand how radical this argument sounds, but consider what it's juxtaposing. Because the United States is increasingly reopening questions many Americans assumed had been settled after the American Civil War. Is birthright citizenship legitimate? Does equal protection still bind the states? Was Reconstruction itself legitimate? 15 years ago, no one would even think to bring these things up. But these are no longer fringe questions. And that brings us back to my central point. If the former Confederate states were restored to political power only after accepting the 14th Amendment, then what are the constitutional consequences if they begin repudiating that settlement? This isn't merely a partisan question. It's a question about the nature of the Union itself. And not to put too fine a point on it, from where I sit, if MAGA is not prepared to accept the 14th Amendment, the states that are currently under the control of MAGA are free to leave. You are not welcome in my United States.